Hey everyone, non-solicitation clauses are an important part of many employment contracts, designed to prevent former employees from unfairly taking away a company's workforce, customers, or suppliers after they leave. These clauses exist to protect businesses from losing key staff, establish client relationships, and critical suppliers due to the influence of employees who resign. While they do not stop former employees from working for competitors or prevent clients from leaving on their own, they restrict active attempts to persuade others to follow them. A non-solicitation clause primarily covers three areas. First, it prevents former employees from poaching ex-colleagues, i.e., convincing or influencing their former team members to resign and join them at a new company or business. This is especially relevant for senior employees who have significant influence over their subordinates. For example, a senior executive in a tech firm may try to persuade key engineers to resign and work for a competing startup. A well-drafted non-solicitation clause can prevent such disruptions. Second, it stops former employees from stealing customers, meaning they cannot actively approach or entice clients they dealt with during their previous employment. If a financial advisor leaves a bank and immediately starts contacting his former clients to switch their investments to a new bank, that would be a clear violation of a non-solicitation clause. Finally, such clauses may also extend to soliciting suppliers of the former company, prohibiting employees who resign from persuading key suppliers or vendors to switch to another company. This is particularly relevant in industries where strong supplier relationships are critical to business operations. Unlike non-compete clauses, which restrict a former employee from working for a competing business in a certain location or industry for a period of time, non-solicitation clauses focus specifically on preventing the active recruitment of people or entities connected to the former employer. Courts in Singapore are generally more willing to uphold non-solicitation clauses than non-compete clauses, as they are seen as a more reasonable way to protect business interests without placing excessive restrictions on a person's ability to work. For a non-solicitation clause to be legally enforceable in Singapore, it must meet two key conditions. First, it must protect a legitimate proprietary interest of the employer. This could be maintaining workforce stability, protecting confidential business relationships, or preventing disruptions caused by key employees leaving with valuable connections. Secondly, the clause must be reasonable in scope, meaning that its duration, geographical coverage, and specific restrictions should not be excessive. For example, a clause that prevents an ex-employee from contacting former clients for 6 months might be seen as reasonable, but a restriction lasting 5 years could be considered excessive and therefore unenforceable. Non-solicitation clauses are also found in agreements between companies, particularly in mergers, acquisitions, or joint ventures, where businesses agree not to hire each other's employees for a specified period. However, such clauses must be carefully drafted to ensure they serve a legitimate business purpose. If they are merely designed to limit competition, they may violate Section 34 of the Singapore Competition Act, which prohibits agreements that prevent, restrict, or distort competition in Singapore. If a non-solicitation clause is found to be anti-competitive, companies involved could face financial penalties and legal consequences. Another key reason for non-solicitation clauses is to protect trade secrets and business connections. Employees who develop strong client relationships or gain access to sensitive information during their employment might be tempted to use that information to benefit a new employer or to their own new business. However, if an employment contract already contains a non-disclosure agreement protecting confidential information, a non-solicitation clause must be worded carefully to ensure it protects a distinct interest. Courts will not enforce redundant restrictions that cover the same ground as existing confidentiality agreements. If a non-solicitation clause is deemed too broad or unreasonable, Singapore courts have two options. They may apply the blue pencil test, which allows them to strike out the unreasonable parts while keeping the rest intact, provided that the remaining wording still makes sense. If the clause is so excessive that it cannot be modified in a reasonable way, the entire clause may be struck down. This highlights the importance of drafting well-balanced clauses that are specific and justified. If a valid non-solicitation clause is breached, employers have legal recourse. They may seek an injunction to stop further breaches and may also claim damages for any financial loss suffered. For employees, it is crucial to be aware of the non-solicitation terms in the contract before making any moves that could be seen as solicitation. Breaching such clauses can lead to legal disputes, financial penalties, and even reputational damage. To conclude, non-solicitation clauses play a vital role in protecting businesses from unfair competition and disruptions caused by employees who resign. However, these clauses must be carefully drafted to ensure they serve a legitimate purpose and remain reasonable in scope. Employers should ensure that their contracts are legally sound, and employees should understand their contractual obligations before making decisions that could have legal consequences. As always, seeking legal advice can help both parties navigate these contractual obligations to ensure compliance with the relevant laws. Thanks for joining me in this video. Don't forget to like, share, subscribe. I'll see you in the next one.